Hey, Dollar.
How now? So, okay, let me not. But I don't want to say I might not be able to participate because my internet connection is terrible where I am. Okay.
Good afternoon, delegates. It's 2 o'clock and the session is declared open. My name is Tobenna Erojikwe. I'm the chairman of the board of governors of the NBA-ICLE of Continuing Legal Education. And it's my pleasure to welcome you to today's training. Today is session 5 of the civil litigation training for lawyers. And once again, I'm happy to the distinguished faculty who have been taking us through the training sessions. The first tutor for today is Mrs. Abimbola Akeredolu, Senior Advocate of Nigeria, Fellow Chartered Institute of Arbitrators, UK. Abimbola Akeredolu-San is a partner in charge of litigation, arbitration, and alternative dispute resolution at the leading Nigerian law firm of Banwo and Igodalo. Prior to obtaining a degree in law, Abimbola obtained the first degree in French, where she majored in French and took substantive courses in other European languages. The background has been advantageous. This background has been advantageous and most useful in enhancing the communication skills with courts, arbitral tribunals, and clients from all over the world in the course of her practice. She's a senior advocate of Nigeria, a notary public, and a fellow of the Chartered Institute of Arbitrators, UK. She obtained a diploma in international arbitration also from the Chartered Institute of Arbitrators. She has almost 30 years experience in the practice of commercial litigation, intellectual property litigation, tax litigation, labor litigation, industrial disputes, international and domestic commercial arbitration, building and construction industry arbitration, arbitration in the oil and gas industry, and insolvency. She has over the years advised and represented both local and international organizations and law firms on a wide variety of subjects. In 2013, she was appointed Attorney General and Commissioner for Justice in Ogun State, Nigeria. Her resolute commitment to the best interests of her clients in the course of mediation and negotiation of settlements, litigation, arbitration proceedings, and the success of proceedings in which she is involved in is an attribute for which she is often commended. She has acted as arbitrator in a number of domestic arbitrations. She is a current chairman of the Lagos Chamber of Commerce International Arbitration Center, LASIAC. Today, just permit me to mention that Ms. Akeredolu has been a huge supporter of training and mentorship initiatives, especially at the NBA Lagos branch, and we are grateful to have her on board again today. She'll be speaking today on pretrial issues, applications, and steps, pretrial conferences, case management conference, etc. So, distinguished delegates, it's my pleasure to welcome Mrs. A to take us on. Thank you, Mrs. A.
Thank you very much, Tobenna. Once again, I must commend you for the wonderful work you are doing in terms of continuing legal education. Thank you very much. And I commend the larger body, the NBA, for this brilliant idea by which even I, and I know a lot of seniors, those who are senior to me, have learned. Thank you very much. So I dig in straight on. Pretrial issues. So it's been broken down into sub-segments, and I will start with preliminary objections. Typically, when you are served or when your client is served with a claim, an originating process, you look at the originating process, and of course, the natural emotion is what nonsense. So even if as much of the claim is relevant, is correct or true, there's a natural urge to want to fight it. And the fighting doesn't start with defending it. You are often inclined to also go on the attack. And if you are to go on the attack, you need to study the process with which you have been served in a thorough manner. And there are so many reasons. There could be, it is human to err, they say. So as human beings, we will always make mistakes. And the counsel to the plaintiff or claimant who generated the processes that are served on you is a human being and will naturally err. And the mistakes or shortfalls of an originating process will fill a very long list. The kind of mistakes that, well, my training I started litigation was to first look at a process. You look at it from the very beginning and you look at the heading. If you find that maybe the heading says in the High Court of Oyo State, in the Lagos Judicial Division, holding at Igboshire, you know straight away that there's a problem. Because the heading is like an address. Is it possible to have a process that emanates from the High Court of Oyo State and then now has the Lagos Judicial Division? There's already a problem there. But then the law has moved away from technicality. So you put it in your bag of ammunition. One reason you can use to destabilize the process. You then look at the parties. The plaintiff says is XYZ Enterprise. Can XYZ Enterprise, is XYZ Enterprise a human being?
Okay.
Or is it? I would be very grateful if everybody can mute themselves. I'm getting distracted by the background. Leonard Silk, please mute yourself. I can see from here. Thank you. So, XYZ Enterprises is not a juristic person. It's not a natural person. It's not a corporate person. So you have another ground on which to attack the process. I'm laying a foundation and I'll take the issues one by one. So they then sue you. Maybe your name is ABC Nigeria Limited. They now sue ABC Nigeria PLC. You know it's you they intend to call, but you know that, well, that's not my name. You have another basis on which to attack the originating process. Okay, so I will, on that premise, having laid that foundation, I will do preliminary objections. What is a preliminary objection? I mean, we all hear about it all the time. We think we know it, and I'm sure we do, but I don't think we'll lose anything again if I reiterate what a preliminary objection is. A preliminary objection is an objection taken before the hearing. It should be taken before the hearing. So it is preliminary to the hearing. It's also an objection against the regularity of a court process. Remember the foundation, the few foundations I just laid, just about headings and name, nomenclature only now. That's where we still are. So it can be described as an objection against the regularity of a court process, either the main suit or a process, a motion, or any other process of court. However, the objection must be such that if it is upheld or sustained, it will terminate the proceedings. That is the essence of a preliminary objection. It operated properly. When operated properly, we find a lot of preliminary objections that do not achieve this purpose. But a preliminary objection, in order to be so validly and correctly, must be such that it brings an end. It will terminate the proceedings. It will terminate the proceedings against which it is being invoked. Otherwise, it really shouldn't be called a preliminary objection. And ideally, preliminary objections should be based on pure law. To be a preliminary objection, it should be based on pure law. So it will not be proper, and you can't call it a preliminary objection if you have to adduce facts. And this is where the knotty issue lies. and I will quote some Supreme Court decisions. And the Supreme Court in a case said, a matter, therefore, which is raised by way of a preliminary point, but which may be answered if evidence is adduced, cannot be properly raised as a preliminary objection. Such a matter is more properly answered by evidence during the trial and shall constitute an issue for determination at the trial. So I come to preliminary objection, and this dovetails into the issue of demurrer. A preliminary objection, properly so called, is, like I said, based on pure law. So, for example, a party files a claim maybe in contract and says there was a contract that you have breached, for example. So in the originating process, you see facts that establish what are the elements we are taught in law school for contract. It's offer, acceptance, consideration, all of those ingredients. Once they are there, you have a contract. So in this originating process filed on you, you see offer, you see acceptance, you don't see consideration. And the man is saying you don't see facts that support consideration. You see facts that support offer, you see facts that support acceptance, you don't see facts that support consideration, and the man is alleging breach of contract. So an ingredient is missing. So you are entitled in that case to bring a notice of preliminary objection against the suit for not disclosing a cause of action. There's so many things, there's so many reasons you can bring. And why we say a preliminary objection must be based on pure law is that based on that statement of claim alone, don't forget you found offer, you found acceptance, you haven't found consideration, and the man is alleging breach of contract. So based on just his statement of claim and writ of summons, if you bring a preliminary objection, straight away you don't need an affidavit. Because what you are then saying to the court is that even if all of the facts he has stated are correct, so what does that mean? That all the facts he has alleged are deemed admitted. You are not going to contest the facts in the statement of claim. I admit them. Even if I admit them, it cannot sustain his claim. This, I want us to juxtapose this scenario I just painted with a situation where you see a statement of claim, but in order to sustain your objection, you then file a motion or notice adducing facts that cannot be found in the statement of claim. Then you have strayed into what we call the realm of demurrer. You are demurring. You are bringing fresh facts. So it's no longer, really, ideally and correctly, it is no longer a preliminary objection. In determining a preliminary objection, the court should have resort to the statement of claim writ of summons alone. And this point, whereas in the other scenario where you file a motion or notice, that should be the subject matter. What you should be doing in such a case is file a statement of defense, put your objection in the statement of defense, then come by way of a motion or notice, asking the court to set down that point of law for hearing. Don't forget that by filing a statement of defense, you have also put your own facts. These facts that will sustain your objection, you have put them before the court by way of a statement of defense. So this, sometimes I have found in my experience that many times when people file a preliminary objection, I will say, no, there's demurrer. It appears that even some courts, I'm sorry to say, don't understand that very fine distinction. You know, you are submitting from the top and the whole of your body, and it's like water off a duck's back, because the authority to which you are submitting doesn't appreciate that fine point. And the Supreme Court has said it times without number. A legion of authorities, a plethora of authorities on this issue. I want to bring our attention to the fact that by Order 22 in Lagos and many other rules, demurrer has been abolished. Okay, so let's look at this demurrer. We all hear about demurrer. What is demurrer? And I will go a bit historical or into the etymology, the origin of the word demurrer. Okay, the rules say no demurrer shall be allowed. Any party, and the rules go on to say, any party may by his pleadings raise any point of law, and the judge may dispose of the point so raised before or at the trial. Okay. In the case of Tijani Bambe and others against Elijah A. Aderola, reported in 1977, Supreme Court, pages 5 to 6, the Supreme Court said the word demurrer came from the Latin word demurrare, meaning to wait or stay. And in that case, the Supreme Court went on to say, before demurrer was abolished, one of the methods of fighting an opponent's pleadings was by demurrer. The party who demurred would not proceed with his pleading, but having raised point of law as to whether any case has been made out in his opponent's pleading for him to answer, awaited decision on that point. Demurrer is a long-standing procedure known to common law for determining suits on points of law only. A demurrer is a known and well-accepted common law procedure which enables a defendant who contends that even if the allegation of fact are stated in pleadings to which objection is taken are true, yet their legal consequences are not such as to put the defendant to the necessity of answering them or proceeding further with the cause. The whole basis of a demurrer is to short-circuit the action by a preliminary point of law to show that the action founded on the written statement of claim cannot be obtained. So the issue of preliminary objection, demurrer, they are related. The rules of court in abolishing demurrer, want to put an end to this issue of when you have an objection to the suit, you then come by way of motion and adduce new facts. In abolishing demurrer, what the rules want to do is that if you have a pure point of law, okay, bring it by a preliminary objection, and it will be determined based on the statement of claim, meaning that you have to admit everything the man has said in his statement of claim. And you are then saying, even if everything he says is true, I admit it, the claim cannot be sustained as presently constituted. That is the kind of language we use. Whereas if you then need, for instance, if you say the action is statute barred, the man in his pleadings has not mentioned the issue of statute bar. Whereas you believe that the case is statute barred, and you need to bring in letters and things like that to show from which the court is to take evidence that the issue is statute barred. You then need to file a statement of defense, then raise the issue as a point of law. Don't forget that in filing your statement of defense, you would have front-loaded your documents, put forward your evidence, and then the letters that will establish that the case has been statute barred will be in your bundle of documents filed in support of the statement of defense. Then you can bring a motion asking the court that determine this point of law that I have raised in paragraph 3 or 4 of the statement of defense, because I believe it will bring an end to the suit. And the court will have no choice but to set the issue down for hearing, having been seized of all the facts. So it's important that we don't shortchange ourselves by understanding this fine distinction and not wasting our time and precious judicial time. I will rest on the issue of plenary objections and demurrer. I'm sure questions will come. So, remember in the scenario I painted when we started, you get a process, and the plaintiff or claimant says he's XYZ Enterprises. And is XYZ Enterprises a natural person or an artificial or a corporate person? Straight away, from our knowledge, enterprises cannot sue, except he then says XYZ Enterprise, ABC, trading under the name and style of XYZ. But the way he has couched it, as in my example, shows that there's nobody before the court. And that brings me to the discussion on the issue of locus standi. Okay? Locus standi, and we've heard a lot about locus standi. Locus standi denotes legal capacity to institute proceedings in a court of law and is used interchangeably with terms like standing or title to sue. It has been defined as the right of a party to appear and be heard on the question before any court or tribunal. It is the right or competence to institute proceedings in a court for redress or assertion of a right enforceable at law. So, what is the significance of locus standi? Locus standi means the right to stand before a court. So if you are not a natural person, a human being, you are not a creation of a corporate personality, how? As far as the court is concerned, you are ideally a ghost. So if you are served with a process that is filed by a ghost, you will do very well. Bring a preliminary objection. If you find that in the statement of claim, it is clear that this person is not a corporate or human being, no natural person, then you can bring your objection purely on points of law. But then if there are documents or things you need, further facts you need to put before the court to show the court that, this plaintiff is a non-existent, is a ghost as far as the law is concerned, then you file a statement of defense, then bring a motion asking the court to set down the issue of the locus of the plaintiff to institute the proceedings. And the courts, I think, well, I'm not sure if this is Supreme Court or Court of Appeal, but in Nigeria Airways against Locus, reported in 1990, 7 Nigeria Weekly Reports, part 163, page 392, specifically at page 406 to 407, reported at 404 though. The court said, where a court at a preliminary stage makes a finding that the plaintiff has no locus standi to prosecute an action, the only course open to it is to strike out the action since it has not been tried. So on locus standi, the court can only strike out and not dismiss because you will be doing this at a preliminary stage. It's not being heard on the merits, so it will be a striking out. But then, in the case of Pacers Multidynamics against MV Dancing Sister, reported in 2003 Nigeria Weekly Reports, part 648, page 241, but specifically at page 260, the Supreme Court said locus standi is a threshold issue. When a plaintiff, by his pleadings, fails to show that he has a locus standi to institute an action, no issues in the case can be gone into. Not even the question whether or not the statement of claim discloses a cause of action. The only proper order to make is start striking it out. And the courts in Nigeria Airways and Locus, which I cited earlier, also made the same point. So what the court is in effect saying is that if this plaintiff is neither a natural person, is not a corporate person, doesn't even have sufficient interest in the case, you can't even begin to go into whether there's a cause of action. Who is before me? Is there a person before me? That's the first question. And it's a threshold issue to jurisdiction. The court can only exercise jurisdiction over for want of a better word, a real person. So if before the eyes of the law, the plaintiff is a ghost, then there really is no case. You can't start even going into cause of action. And we've all heard about the locus classicus on locus standi, which is the case of Desonya against the president of Nigeria. And then we've heard also about the case of Owoduni against the registered trustees of Celestial Church of Christ. I'm sorry, I don't have those citations immediately available. And it will look, if you read those two authorities, it will look as if the Supreme Court in the earlier case, which is the Adesonya case, said that Adesonya had no locus standi to bring that action. Whereas many years later, The Supreme Court in Owodunni and Celestial Church of Christ said Owodunni had locus standi. And you begin to wonder, the only difference between the two cases, one is public interest, that's Adesanya, and Owodunni is private. However, the difference is in the outcomes of the two Supreme Court decisions is that, in Adesanya, if Adesanya had been interested in contesting for the position of Senate President, which was the case he took to court, the outcome would have been different. But he wasn't interested in becoming Senate President. He was just arguing a case for the propriety of the process. Whereas in Owodunni and CCC, Mr. Owodunni wanted to become the head of the Celestial Church of Christ. So the court said he had a locus because he was interested in contesting for that office. So the issue of sufficient interest, apart from being a natural person or being a corporate person, the issue of, do you even have sufficient interest in this matter? The same thing Thomas and Olufosoye. The headship of the Anglican Church was in issue, and Irene Thomas, Mrs. Thomas, and a group of others went to court to dispute the process for the appointment. And the Olufosoye bishop, I think it was a bishop, went to court, defended the action and said, you don't have locus. And the court, up to the Supreme Court, upheld the fact that the plaintiff in that case did not have sufficient interest. Over the years, it appears that the scope of what you need to show sufficient interest has, of course, been what I would call more liberalized from the Adesanya position. So, I mean, I know questions will come, so I'll stop there on locus standi if I'm to achieve anything today. So I come then to the issue of reasonable cause of action, whether such is disclosed or not, whether a cause of action is disclosed or not disclosed. Okay, a cause of action has been described as, and I will take my bearing from the case of UBN, Union Bank Nigeria against Pennymat, Thomas and Olufosoye, Savage and Uwechia, Egbe and Adefarasi, where the courts consistently and in all those cases said a cause of action consists of a bundle or aggregate of facts in the relationship between the parties, which the court would recognize as enabling the plaintiff to enforce the claim against the defendant. In Ayomboye and Balogun, it's defined, the court held that a cause of action is the entire set of circumstances as disclosed in the plaintiff's statement of claim, which gives right to sue a defendant for a particular relief or reliefs. So, at times, like in the example I gave earlier, if, for instance, you are filed with a statement of claim that shows it's a claim in contract, it shows offer, it shows acceptance, you don't see consideration, and the man is alleging breach of contract. Can that be said to disclose a cause of action? I would say, and if you remember that the definition of cause of action is bundle or aggregate of facts in a relationship which the court will recognize as enabling the plaintiff to enforce a claim against the defendant. So if a man shows offer, he shows acceptance, he doesn't show consideration, and he's alleging breach of contract, those set of facts and circumstances which a court will construe, of course, based on legal principles. So if you are alleging breach of contract, the court will say, okay, your offer was consummated on Monday, 15 June. Acceptance came on 16 June. So where's consideration? Straight away, that shows that the case does not disclose a reasonable cause of action. I know the questions will come, so I'll stop there for cause of action, but please feel free to ask any further questions you may have. I have been asked to speak on failure to fulfill conditions precedent. I spoke extensively about conditions precedent on Monday, but if there's anything that remains outstanding, please, so that I can cover other areas, please let me know by way of questions. Striking out of pleadings. This is what I call a very nifty legal tool that can be used, and it was often used under the older rules. I have not seen it used recently. I remember my former boss, Malam Yusuf Ali. We had this case, and we were defending, and the statement of claim was so full of all sorts of relevant materials that at the end of the day, we struck out, I think, paragraphs 4 to, it was a 15-paragraph affidavit, statement of claim, and we struck out paragraphs, I think, 3 to 12 or 3 to 13. And the only thing left were the introductory paragraphs of the claim. And naturally, the case died a natural death because there was nothing to sustain the claim after the striking out of all of those paragraphs. So, as counsel for plaintiff, you need to be sure that every paragraph, every averment, every paragraph of your claim is relevant, is not frivolous, is not vexatious, does not constitute an abuse, and is not unnecessary. Okay? The rules allow a party to pray that paragraphs that are frivolous, ridiculous, vexatious, abusive be struck out. It's allowed under the rules. So, I go on to consolidation of actions. Please, if there are questions on this issue. And striking out of pleadings also leads to me to discuss striking out of paragraphs of affidavits in motions. I don't know, those who have practiced with or against me know that this is one of my favorite areas. The Evidence Act 2011, I think it's paragraph section 115, says an affidavit shall not contain extraneous matter by way of prayer, pleading, and all sorts of things. When we are drafting affidavits, if they are to be correctly done, your affidavit should not be asking the court for anything. If you want to ask the court for anything, the proper way to go is by way of motion. If I find a prayer in an affidavit, those who know me in my practice know that I will come against that paragraph with everything I have. And the Supreme Court in Bameyi against, I think it's the state and Bameyi or Bameyi against the state, said that. And how do you, okay, so maybe I'll come to that. How do you know, or how do you determine what kind of averment should be in an affidavit? Affidavit is a statement of facts that will support your application. An affidavit should not contain conclusion. What is a conclusion for the purpose of this discussion? A conclusion is when you say the whatever is incompetent. Hello, who are you? Are you the court? The only person that should be making an assertion about the competence or otherwise of whatever is the court. And extraneous matter, what are the kind of things we find? A conclusion, prayer. Then in some affidavits, you find them saying to the court, I'll be asking the court to do something, to award costs in their favor. That's a prayer. It has no place in an affidavit. And the case of Bameyi against the state, the Supreme Court said how to run the test is if the averment is something that is properly left, should ideally be properly left for counsel to articulate before the court, it has no place in an affidavit. If the matter is such that only the court can conclude on it, it has no place in an affidavit. So when we are drafting affidavits, there's a way to say the same thing. You are supposed to just even depose to facts. You are not to make conclusions. You are not to ask the court for to pray anything. Just state the facts that will support your application. And then in your written address, and we thank God for written addresses. Before the advent of written addresses, you would articulate your position in the court. Now you even have time to put it in writing and prepare, and you're better prepared because you've had the opportunity to reduce your submissions into a written address. So so striking out of pleadings and paragraphs of affidavits, if you have any further questions, please send them. I come then to consolidation of actions. If an action, sometimes you might find that an action has the same parties and perhaps a related subject matter. That's in that kind of case, instead of battling in different courts or on different fronts, an application can be brought to court to consolidate the actions. This is one of the preparatory steps that can be taken for the commencement of a trial. And so it's a process whereby two or more actions pending in the same court. When I say same court, it doesn't have to be the court of Judge A alone. It can be in the Lagos High Court, for instance, and in courts, one in Judge A's court and another in Judge. So the consolidation is the process whereby two or more actions pending in the same court are by order of court joined and tried at the same time. So the actions, even though they are separate and distinct, they are tried together simultaneously in the same proceedings. So it's a joinder of two or more actions for trial in one single proceeding. The rules, High Court rules, give the courts the power to consolidate. If there are any other questions in that regard, I will take them. I'm trying to watch time. Okay. So I come to interrogatories, discovery of facts, procedure, consequences of non-compliance, and also discovery of documents. There are times I will start by sharing an experience I had. I once was retained to defend an action for a big Nigerian company, very big company. And we kept asking them for facts with which to prepare the defense. And nothing was forthcoming. So I went there and saw the company secretary and said, look, what's happening? We need to defend. This case is a big one against you. We need to defend it. And you're not giving us the materials. I'm not even responding to our letters. What is the problem? And the lady said, well, they've just come out of the transaction and a lot of their documents are in the data room. I think there was a due diligence and they don't have access to them. And I said, well, I mean, if you need us to go in there, and she says it's absolutely impossible. Like, I don't know. She says we have to go and find a way that they honestly can't. And I took some facts from her, but we didn't have documents. So under the rules at the time, you could ask for inspection of documents. And I think the present rules still have them. So I wrote a letter to the plaintiff and said, you know, these are these documents that you have pleaded. We want to inspect and take copies. in those days, we didn't have front loading. Perhaps if we had front loading, then that wouldn't have been necessary. So they gave me the documents, I took them and made a copy. And believe you me, based on what I got from them, we were able to articulate a very good defense. So discovery of documents, discovery of facts, under the rules of courts, is a very nifty tool with which a lawyer who knows what he's doing can, let me put it in layman's terms, reduce the scope of his headache. So if you apply for discovery of facts, based on the pleadings, you make a request to the other side saying that I would like you to tell us on oath the answer to these questions. And your questions, which have been elicited from the pleadings, would be such that they will be constrained to answer them under oath. And because it's under oath, you are able to see better the scope of what it is that you need to be proving. So if, for instance, they admit certain things under oath, facts once admitted need no further proof. The same thing, now that we even have front loading, discovery of documents is no longer as useful a tool as it used to be before the advent of the new rules all over the country. So under that heading also, you have notice of admission, notice to admit facts, notice to admit documents. Because we now have front loading, though, I mean, you can still use them where it becomes necessary and you find that a party is being coy with some facts and some of their documents. But the essence of front loading now is so that there will be absolutely no surprises. Under the old dispensation, if you ask for notice to inspect and take copies and the party did not, omitted, failed, refused, or neglected to give you those documents, the plaintiff will not be allowed to use those documents at the trial if he doesn't give them to you. And I think it was because of all of this that we came to the idea of front loading, so that absolutely nothing will be hidden. And if you have a court and a lawyer that has this background will understand why, if a party blindsides you with a document at trial, you are entitled to say this document can absolutely not come in, because the whole spirit and essence of the new rules is that a party shall not be taken by surprise. Setting down for trial. A lot of these points I've been asked to speak to were things that obtained under the old dispensation. Once pleadings have been concluded, complete, claim, defense, reply, all in, you could ask the court to set the matter down for trial. But that, I think, has been, all of that has been taken care of under the new rules, so that all the preliminary applications are taken at the pre-trial conference now, at least in Lagos. I speak for Lagos. I cannot, well, and the Federal High Court doesn't have pre-trial conferencing. The Abuja court in Abuja, I think, has the FCT, High Court of the FCT has pre-trial processes. The forms for which you will apply for setting down for trial are in the new High Court rules. Once pleadings are completed, you file your PTC forms, plaintiff files, defendant files, and those forms can be found at the back of the relevant rules. And if you have any preliminary applications, if you need an interpreter, if you need whatever type of preliminary matter, it is taken care of at the pre-trial conference. A lot of different judges have different styles, but pre-trial conferencing is part of the ADR mechanisms that have been adopted or infused into the High Court rules to promote dispute resolution. So ideally, a judge comes off his or her high throne and sits. Some courts will sit at in the space of the registrar without the court paraphernalia. Even counsel are enjoined to dress down. You don't come with your wig and gown, and then you discuss whatever it is. But for me, the jury is still out as to how successful has this pre-trial conferencing and case management conferencing been. I wish we were a country that took statistics. We have been at it, I think, for it's over 10 years now. I think it came with the 2004 rules when the Wolf reforms were passed in England, and we took it on. If we were a statistic-taking country, we would do well to explore how we were doing before the 2004 Lagos rules and how we are doing now in terms of how many more cases have we been able to resolve, either, at the pre-trial stage. So if we can find that we resolve more at the pre-trial stage, then that would be really good. It would make a case for continuing with that process. But if we find that it has only prolonged the life of litigations, then we really should review our positions. I will want to stop here and take questions. I know the questions have been coming fast and furiously. So I beg to appeal that those questions that are not related to my presentation, forgive me if I dodge them. And I use the word dodge advisedly. Thank you.
Thank you very much, Mrs. A. Once again, very exciting delivery from you. Thank you very much. We're grateful. I'll hand over to Nta so that we'll continue and then we'll speak a bit after it. So Nta, here we go.
Good afternoon, Lenesio.
Good afternoon.
So just, I'll try and, I'm going to sift through the questions and just focus on the ones because I've seen lots of ones, lots of questions.
Okay, let me also open them and then so I can follow. Wow, yeah. 15, well, that's not too bad.
They will start pouring in once we start.
Class action. How does one proceed with the same where the claimants have different claims?
Okay.
It will be very risky if they have different claims and you try to go in a class action, except you are able to, well, there's a way to arrange your claim so that you have, even though it's one class action, you can put them in different buckets at the end, whereof the claimant claims, claimants, 1 to 10 claim 5 naira, claimants 10 to 15 claim specific performance and 5 naira and whatever. A lot will depend on how different are their claims. So if the claims are radically different from each other, you will do well to, it will be safer for you to file different suits for them. But if the claims are different as to only quantum, but in terms of subject matter, the claims are the same, only that maybe one person wants 5 naira, another person wants 15 naira, another person wants 20 naira, then you will structure it in your operative part of your claim. I hope that helps. Distinction between private and public documents. Now, that's Evidence Act, not for here. Read your Evidence Act and the answer will be found there. Thank you, Mr. Chukwumanwachuku. Good afternoon. I don't know about most learned, but the most, but thank you.
No, we're not going to take that. That's an
okay.
arbitration.
Arbitration, madam. Please now. If one is sued and files a PO without a statement of intent, praying the court to dismiss the suit that is incompetent on good grounds, that's a demurrer. What is your definition of good grounds, madam? good grounds. Oh, sorry, I don't know if Chukwunyere is a man or a woman. I'm sorry. What is good grounds? You see, as lawyers, we cannot be vague or nebulous. Good grounds, you know, they are in substantive law, what they taught us in university, they tell us the ingredients. So incompetence would mean that maybe one of the ingredients is missing. And that's a good ground. But, you know, files is PO without a statement of intent. And so you're good. What you mean is grounds of law. If you file a statement of defense, praying the court to dismiss this. No, we need to talk more. Your question has too many open ends. Your delivery has been most educating. My question is, thank you. My question is on the issue of non-juristic entities. Is it possible a non-juristic person like XYZ Enterprise to be an attorney in a suit for a juristic person suing on behalf of? And so you has to be stated on the process now. But if XYZ Enterprises alone comes, I will strike that suit out before you drop of a hat. Whereas if you say principal attorney, Mr. Chukuma Nwachukwu suing as principal attorney for XYZ, aha. Of course, you must then show that you have a power of attorney to do that. Judith, what happens when a plaintiff is not a person as recognized by law, but has sufficient interest in that the business owner is being owed money by the defendant? Plaintiff is not. Hey, you say you have sufficient interest, so you this is basic law now. If the plaintiff is not recognized by law, but somebody that is recognized by law will articulate it for him. And typically, in such a case where you have a non-juristic person, a natural person trading under this name and style of that entity will be the one who will file the claim. Samuel, thank you very much. Thank you. My question, if a senior magistrate holder has no jurisdiction to entertain a suit, what is the proper order to make? You strike it to entertain. It's striking out now. Is it to strike out the matter or to send it back for reassignment to the chief magistrate? I think it's striking out. But then administratively, he may be, I don't know if he should send it back for reassignment. I think his job really should be just to strike it out. I always thought there was a preliminary objection based on law and one based on mixed law and fact. Preliminary objection. In a situation where points on law are raised and facts need to be stated from facts pleaded instead of claim, what would one file as a defense counsel? Sorry, I don't get this.
Actually, where the jurisdiction and other facts.
Where points of law are raised and facts need to be stated from facts pleaded instead of... I said this now. If you are served with a statement of claim and you have objection to the suit, but to sustain your objection, you need to bring more facts. You need to bring documents. You should just go and file a statement of defense, then raise your objection in the statement of defense. Don't forget that when you file your statement of defense, you will also file your front-loaded documents. So everything you need to found your objection will be in your statement of claim, in your statement of defense, sorry. Then you bring a motion asking the court to set down that point of law, and you must have set it out as a point of law in your statement of defense. Okay? Joshua Tony, can a preliminary objection be raised against the motion on notice? Also, can a claimant be, I've done it before. If you have solid reason to believe that the motion on notice is improper, can a claimant be granted leave by the court to amend the statement of claim the moment the defendant starts raising objections on the irregularity of the statement of claim? Well, it's neither here nor there. A lot will depend on the court and the nature of amendment that you want to bring. If you want to amend to revive a claim that really should have died or that has no merit, I don't know. It will depend on strength of the other counsel, but you can try. Suleiman Abubakar, if some paragraphs contravene section 115 while others are not. Buhari and INEC says the affidavit is incompetent because court cannot pick and choose. Wow, thank you for this. Oh, to pick and choose the paragraphs to believe. Why are some judges only striking out paragraphs that offend and use the ones that are statements of facts against the decision? Is there authority allowing what the courts are doing? Well, I mean, that's what we've always done. You know, I think it's in the case of IMB and Willoughby, where the Supreme Court said the court is not a Father Christmas. Court will give you what you ask for if you are able to justify your asking. So if I say court, strike out paragraph 2, 3, 4, and 5, except the remaining paragraphs have no, the remaining paragraphs cannot sustain the prayer, then yeah, maybe the affidavit can go. I've done it before where I've struck out so many paragraphs, and the only paragraphs left were introductory paragraph, and this oath is made under pursuant to the rules of the High Court of, Evidence Law of Lagos State, Oath Act of Lagos State, and those were the only paragraphs left. So we told the court, please strike out the whole affidavit because there's nothing left. That even the fact that he is swearing the oath bona fide is suspect, since every other prayer has collapsed. So maybe we can only leave his name, and we already know his name. So the affidavit died a natural death. But thank you for giving me this Buhari and INEC case. I shall go and read it. It will be a nice way to kill an application that you don't want the court to hear. Because if a motion must be supported by affidavit, and the affidavit has died by virtue of the authority of Buhari and INEC, then there's nothing left. There's no affidavit to support the case. So the motion itself then becomes incompetent, and that is a natural death. Thank you very much. I shall go and study Buhari and INEC and acquaint myself very well with it. How to bill a client for legal services. Oh, that doesn't relate to my presentation. Galaxy J5 Prime, sorry. Thank you so much. Thank you. I would love to have a soft copy of the presentation. All right. Leonard, thank you. Thank you. Given the level of illiteracy in our community, go for fundamental rights. That doesn't relate to my presentation. If in an affidavit, I honestly believe that this suit is incompetent. Is this a disposition or conclusion? We also say I verily believe. This it's a conclusion, as far as I'm concerned. Especially if the lawyer deposing, it's definitely a conclusion. It's definitely a conclusion because he has concluded. Thank you so much. Thank you. Is it wrong to include prayers in an affidavit in support of an undefended suit? It is wrong. The Evidence Act, Section 115 says it is wrong to have a prayer. It's an extraneous matter. It has no place. If you have a prayer, put it in a motion. Thank you, Abibola Adu. Yeah, you haven't paid for the name, though. In an instance where the subject matter of the dispute has been burnt or destroyed, is it right to state that the court does not have jurisdiction? Subject matter of the dispute has been burnt. If it has been burnt or destroyed, then why are you litigating it? There must be something of value there that is being litigated. You know that some subject matters will survive even the death of a party. So a lot will depend on what kind of subject matter it is. Larry Ibrahim, on Locus standard, my local, okay. Your network went off when I was talking about Locus standard. I understand that you can get it's being recorded now, so the person.
Yes,
okay.
Yeah. We're going to send out. It's going to be posted. Yes.
Okay, great. So Larry Ibrahim, you get it. Yakubu Adam, what's the difference from preliminary objection and demurrer? So you may need to watch it when they send it out again. And I think I made the point.
Yes, ma'am, you did.
Not as a question, but an observation. Learners did not allude to the fact that upon receipt of statement of claim, the counsel for the defendant should also seek to discover where a reaction, if it is required. Yes, I agree, Joshua Tony. So if a pre-action notice was not filed, you can file a preliminary objection. And with that one, you don't need to file an affidavit or a statement of defense, because if on the face of the statement of claim there is no evidence that a pre-action notice was filed, that really should be able to kill the suit. Where a juristic person, Richard O. Olakule, where a juristic person and an individual were sued, but shortly before trial opens, the individual dies, can we sustain a suit against the company? It depends. Like I said, there are some suits that survive. If the man is suing for his pension, of course you can. His family can step into his shoes and sue for his pension now. Yeah. Chief Yomi Aliu, son. Sorry.
The next question is supposed to make us laugh. How do you maintain this beauty and brains?
That's, I was hailing him. Our academy. Chief Aliu. I'll see you later. Good afternoon. What are the challenges being faced by lawyers in civil process? No. Mr. Umar Shehu Kiari, I'm not able to answer this because it arises from my presentation. Thank you. Casey Okoli, where a local government sues a business name without the name of the business name. Oh, I'm sorry, Casey. I can't get my mind around your question. Good afternoon. My question is, what is the difference between striking out and dismissing, and the effect of each situation? It doesn't arise from my presentation, but I will tell you, when you strike out, the plaintiff can come back again. But when it's dismissed, yes, you can come back, but you can only come back on appeal. It's very, short answer. I'm sure there's a whole essay that can be written on that. If a paragraph in an affidavit contains a prayer and you ask for the paragraph to be struck out and the same prayer is in the written address, does it mean that such an application is no? You see, the Evidence Act speaks to affidavit. An affidavit shall not contain extraneous matter. It doesn't talk about written address. So what the court said in the Bameyi case is that if what you are saying in an affidavit, the proper place for it is the written address, then it should be struck out. It can be in the written address, that's fine, but it shouldn't be in the affidavit. In the affidavit, in the written address, you can say it's incompetent, it is preemptive, you can make all your conclusions in the written address. You can make all your prayers, they should be struck out with substantial cause. You can make all of that in the written address, but not in the affidavit. Okay, Precious Aire, I hope that helps. Olubukola Shomolu, are elements not required to be in an affidavit aside from facts correctly stated? Strike out the affidavit and therefore the suit. I don't understand that, I'm sorry. And time is not a friend. Gabriel Oguche, does a non-juristic person have legal capacity? Yes, a non-juristic person, an enterprise, for instance, is run by a person. That person can appoint an attorney. Please, what is the success probability of a PO brought on a motion with a statement filed in land matter where territorial jurisdiction is an issue? Nah, this one, Philip Akpavi. Thank you, Leonard Silk. Thank you, Victor. My question is, the practice of merely editing statement of claim in drafting statement, allowing parts whereof is in the statement on oath, good practice, or does it offend the rules of affidavit evidence? I don't think that witness statements on oath are covered by or contemplated by the Evidence Act. So, but when you are making an oath, you really should we try to follow the rules of the Evidence Act, because you are going to be, it's actually an oath. So maybe the Oath Act is even more relevant for that purpose than the Evidence Act. Professor Achara, the learned Silk agree that Supreme Court decisions such as in Ajayi Adibi have led the courts below it to promote avoidable litigations through is rejection of court rules that require questions of law. Ah, Professor, I don't I don't think it comes up from my presentation. Where a process does not indicate that it's been instituted through a lawful attorney, but an attorney appears when the plaintiff, can such suit be challenged? I don't understand. I'm sorry. Will you still need to file your defense first before raising a plenary objection that is anchored on jurisdiction? No. If it's pure jurisdiction, but you see, we lawyers have cleverly expanded the scope of jurisdiction. If it's pure jurisdiction, as in this court is not the proper court to hear it, you don't have to file your defense first. The important thing, what makes you need to file a defense is if you need to put more facts before the court to determine the objection. But if the facts that you are inviting the court to use to determine the objection are stated on the face of the motion, on the statement of claim, then you don't need to file your defense. It's pure point of law. In a situation where the proprietor of XZY and Co dies intestate, and B is owing, sorry, who has the local standard to sue on behalf of Auntie Joy, go and earn your fees. This didn't arise from I know the local standard, but I lectured on local standard as a principle. Can apply what I thought to resolve the issue. Should the preliminary objection raised purely on points of law be supported with an affidavit? Nope. Go Harrison. Prof, with the learned silk. Oh, okay. We've seen this before. Where a defendant filed a statement of defense and also filed PO on compliance with the law in respect of service outside jurisdiction, some courts normally rule that filing statement of he has waived his right. I need clarifications, ma. Wow. I think no, but you see, when there's non-compliance with the sheriff and civil process law, which I think is the law you're talking about, it's a pure matter of law. I don't know why the person filed a statement of defense, but it's not a waiver. It's not a waiver, especially if he raised that issue in his statement of defense. Okay? Mr. Aribi, you are my Lori. On PO and demurrer, I'm of view that a PO for failure to endorse a risk is an exception to demurrer, as filing a defense would mean a waiver of rights to complain. Yes, I think you are looking at the line of the second, the UK and Scan Consult line of cases. You not have waived your right, especially if you then also put the issue again in your statement of defense. If you file your statement of defense and you don't raise it, then you have left yourself wide open. If you file a preliminary objection and for one reason or another, you file your defense, maybe because you want to avoid paying penalty, the issue should be raised in your defense so that nobody can say you have waived your right to complain. Okay? When an affidavit contains the conclusion, how does the lawyer from the other party raise an objection? Will he file a process or argue it orally in court? If it's a motion and the supporting affidavit contains a conclusion, in your counter affidavit, in your written address opposing the motion, that's where you will raise it. Put it in your written address and don't try to argue it orally in court, because the court will ask you, is it in your written address? Kemjika Igwe provides that a partnership can sue in the name of partnership, but you didn't make that distinction because I'm sorry, I'm only a human being. I couldn't have covered everything in the rules. Kemjika.
That's made a statement, I'm sure.
Nuruddin Emmanuel, I appreciate. Thank you. I observe that some actions are filed in the name of firms or business and we do not have corporate personality. Allows the actions may be stated in the name of firms. Can we still maintain a point of law that there is no claimant before the court to confer jurisdiction on the court? Well, research the current state of the law. If a firm, some firms are LLP, means that they are registered, so that they are artificial person. They have personality. For instance, enterprise does not have an artificial personality. It's still the owner, the person who registered the business name that has the power to sue. So, Dr. Raphael Christopher, there is a way a prayer could be presented within the affidavit. I didn't say there's a way you can put a prayer. The best way is to say, I verily believe that the present application ought not to be granted by the court. That's the best prayer you can put. So you're asking the court to dismiss. That's the best way to make that prayer without it appearing as a prayer. Rather than saying the Honorable Court should strike out this application. Where you have to depose to a witness statement, will such conclusions still be omitted? No, the rules that apply to affidavits is not the same. Witness statement on oath is not bound by the strictures of the Evidence Act. Should all motions be supported by affidavits? Please, yes. An motion not survive with the written address alone when the applicant complains about the competence of a further affidavit filed by the other side. I don't know this one, Mr. Emmanuel. I know that all the rules say all motions shall be supported by affidavits. The only type of motion that may not be supported by an affidavit is a notice of preliminary objection based on pure points of law. Chidi, how do I access the recording of the lecture? My internet connection is not at its best. I will answer you about that one.
Yes, I will.
Casey Okoli, where a local government sues a business name is like suing a private company rather than suing a business name. Can the issue of
I think we've seen that.
Yeah, I think so. We're almost at the end. If a defendant headed a local government area as an administrator and committed an official infraction, is now the chairman, does the claimant still retain Locus standi? I don't understand. Is it proper for a court to go ahead with hearing of a matter when a party has a PO challenging the decision of a court? It isn't. But you see, I remember under the Federal High Court rules just before this one, the rules said you must file an objection to jurisdiction within 21 days. If you file your objection outside 21 days and you are extending time to bring the rules even say if you bring it outside, the court should hear it together with the matter. So, and a lot of the time the courts have discretion. So, if your PO comes very late and all of that, the court can decide to hear it together. And if it's an originating summons, for instance, where the evidence is affidavit evidence, the court can hear it together. And in delivering its ruling, will first address the PO. And depending on the outcome of that, may decide to continue with the substantive suit. Courts have that discretion. What's his fate on affidavit? More questions are coming. What's the fate of an affidavit who does not carry the oath paragraph? It's competent, clearly. Okay, I think we're done. Yes, before they bring more.
Yes, we're done. Thank you very much.
Thank you very much.
So, Mrs. A, I think they came prepared for you, the delegates. You know, the feedback we got, the feedback we got the last time was that they were quite excited that you answered a shed load of questions. So you can trust me, they came.
Thank you.
I'll just invite the other panelists for comments before coming back to you.
Thank you.
So I would start with Mr. John Bayeshia, Senior Advocate of Nigeria. Sir, do you have any comments?
Well, my comment is one of commendation that and appreciation, because Mrs. Akredolueze is a product of Ilorin branch, and she began in a very humble way, and she's lifted and she's lifting others. So you can see the way she's relaxed, and she has done quite a lot for us to learn from. And we thank you for bringing her. And also for those of us who are billed to have a stand there, we're also looking forward to our own slot on the date assigned. Thank you.
Thank you very much, sir.
Yeah.
I will invite Mrs. Maya Essien, Leonard Senior Advocate of Nigeria. Thank you.
Good afternoon, everyone. Leonard Silk, Mrs. Akeredolu, my sister, well done. I can't say anything else. Yeah, it was exceptional. Thank you very much.
Thank you very much, Leonard Silk. I can see that my brother, Mr. Tola Oshobi, Senior Advocate of Nigeria, is here, the coordinator. So, Tola, are you there? Any comments from you?
So he said he was not going to be available, that his internet wasn't.
Okay.
Yeah.
All right. Then I'll invite Mr. Yakubu Mikel, Senior Advocate of Nigeria, for his comments.
Well, I was just going to ask my learned brother Silk, that same secret that someone talked about, how are you keeping this beauty? And then I saw again someone talked about the panache. I said, well, by the time she was done talking, I was almost going to say, oh, this session is fantastic, and I would take my leave, but I only to remember that I would be coming on shortly after she has finished. And now I'm wondering whether I'll be able to come with the level of panache with which she delivered her paper. Mine is to commend her again for a job well done, and thank you for bringing this illumination to us. We appreciate you greatly. Thank you.
Thank you very much.
Thank you very much.
I'll now invite Kelechi Nwaiwu for his comments.
Very brilliant presentation. I've learned a lot as well. Thank you, Leonard Silk.
Okay, thank you, Kelechi. Mrs. A, thank you very much for what everyone appears to acknowledge as a very brilliant presentation. I enjoyed it thoroughly myself. This is the second session that you've led on, and we're very grateful to you as always. You always answer when we call you, so thank you very much. And I hope you find the time to join other panel sessions, because it's always good to get your insights. Thank you.
Thank you very much, Tobina. Thank you all. Thank you for such kind comments. I'm grateful to have added value. Thank you.
Thank you, Ma. So we'll now be going to the second session for the day, and we'll be looking at default, summary judgments, and undefended list procedure, and judgment on admission. Our speaker will be Mr. Yakubu Mikel, Senior Advocate of Nigeria. Yakubu Chonoko Mikel is a graduate of Ahmadu Bello University, Zaria, where he obtained his LLB honors degree in 1989. He was admitted to the Nigerian bar on the 12th of December, 1990. He worked at the law firm of Mrs. Danladi Bameyi and Company in Sokoto. Started in November 1991 and was there for 13 years and rose to become the head of chambers. He started his own practice, YC Mikel and Co. in 2003, where he is principal partner with head office in Abuja and a branch in Sokoto. He was appointed notary public on the 30th day of May 2002 by the Chief Justice of Nigeria and elevated to the prestigious rank of Senior Advocate of Nigeria by the Legal Practitioners Privileges Committee in 2011. As an advocate, he has had the privilege of handling several consequential cases, including the opportunity to capture national consciousness as counsel in the Human Rights Violation Investigation Commission of Nigeria, also known as the Okuta panel, set up by President Olusegun Obasanjo following the return of Nigeria to democracy in 1999. In Re Abdullahi 2018, Mikel successfully convinced the Supreme Court of Nigeria to make a novel decision to allow the substitution of deceased defendants in a criminal case for the first time in Nigeria with the administrators of the estate of the deceased for the purpose of preserving the civil rights of the estate. He's a member of the Rules Committee of the Court of Appeal beyond litigation. He has advised on some project finance and facility disbursements. In June 2014, he obtained a diploma in international commercial arbitration from the Chartered Institute of Arbitrators, London, United Kingdom. Was admitted as a fellow of the Chartered Institute of Arbitrators. And it goes on and on. Distinguished delegates, do please permit me to welcome our brother and friend, Mr. Yakubu Mikel, Senior Advocate of Nigeria.
Thank you very much, my brother Tobena. And I'd like to thank you again for the honor and the opportunity. Of course, it's a huge privilege to be invited to share a little bit of what we've come to know in the experience that God has allowed us to have in the course of this practice. And I hope that in the few minutes that I have to speak, I'll be able to add value to all the things that have been built already by my colleagues that have taken the previous sessions. And what we'll be doing today is to talk about default, summary judgments, undefended list procedure, and judgment on admission. Now, from the description of the subject that we have to talk about today, it's clear that having gone into the civil dispute as a plaintiff or as a defendant, there are certain things that you must keep doing consistent with the prescriptions by the rules of court, adhering strictly to the time allotted for doing certain things under the rules of court. Otherwise, failure to take certain steps would come with certain consequences. And that is what we are going to talk about today, a bit of some of those things that we are going to talk about today. So we would see that summary judgment procedure is a procedure that guarantees the expeditious determination of matters before the court. And why do we have the rules of court make these provisions? It is important that time is saved. It is important that costs are also minimized. And so these rules have made provisions for when certain things could be done summarily. And when you are asked to take certain steps and you fail to take those steps, there must be an end to litigation, and the rules of court do not encourage the plugging of the dockets of the court with matters filed by persons who are not interested in pursuing them, or when a defendant, for instance, is asked by the rules of court to take certain steps. If he fails to take that particular step, then certain consequences will follow. So these are some of the things that we're going to talk about today. And talking about, I would begin the discussion by making reference to summary judgment procedures. We've talked about summary judgment as a procedure by which matters are dealt with summarily. Now, described such matters that can be summarily dealt with. And we'll have, as part of those procedures, or part of those matters that can be dealt with summarily, there is a procedure that is known as the undefended list procedure. The undefended list procedure is also a summary procedure.
I think the Leonard Silk is. Hi, Tobin, are you there? I think the Leonard Silk has. Yeah, he has a problem with his connection. So we've lost him.
Yeah.
Okay. I think we're just going to wait for him to connect back again. Hopefully he's able to do so. Okay.
I'm so sorry. I went off. I have been having issues with the network here. I hope I can be heard now. Can you hear me? Okay.
Yes, we can.
Yeah, so I was talking about the types of proceedings that can be done summarily. I talked about the undefended list procedure and then talked about the summary procedure. The undefended list procedure, just for purposes of reference, we can see it in Order 35 of the rules of the High Court of the Federal Capital Territory, Abuja. And then the summary procedure also can be found in Order 13 of the High Court Civil Procedure Rules of Lagos State of 2019. And that of Abuja similarly has been provided in Order 11 of the rules of the FCT High Court. Another, and I would come back to talk about the undefended list and the summary procedure, the proceedings under judgment under the summary procedure. The other proceedings that can be taken summarily is judgment on admission, written admission in pleadings, or written admission by a party before the court, or the 21 Rule 4 of the Rules of Lagos State makes provision for summary judgment with respect to admissions. And similarly, you can find such a procedure being provided for under Order 20 Rule 4 of the FCT High Court rules. Next is another procedure by which another action by which summary procedure proceedings can be adopted is where you have a claim for accounts. You are asking, a claimant is asking a defendant to render account, maybe with respect to a stewardship that he has performed, or he or she has performed. That is also something that can be done summarily, and that is provided under Order 4, Rule 5, and under 12, Rule 1 of the Abuja rules, which is 2018, and on the 6, Rule 5, and on the 14, Rule 2 of the Lagos rules. Now, there is also this action where, for instance, a claimant intends to recover possession from squatters or someone who has moved into a property without the consent of the owner. Now, Order 57 of the rules High Court Civil Procedure Rules of Lagos State and Order 60 of the FCT High Court Procedure Rules of the FCT also make provisions for these type of actions to be dealt with summarily by the court. Now, having said that, as examples of types of proceedings that can be taken summarily, I would like to just dwell a little bit on the undefended list procedure. Now, the undefended list procedure is meant to take care of claims with respect to debt or liquidated money demand. And what is a liquidated damage or liquidated money demand? That has been interpreted in several judicial decisions. And for a claim to qualify as one that can be put on the undefended list, it must be a debt, a liquidated money demand. That is to say that it must be a claim that can be ascertained with mathematical exactitude. It has to be something that has been predetermined, either by way of contract, if there is a certain agreement in a contract to say that a certain amount of money is going to be paid upon breach of that particular contract. Where there is such a breach, then whatever amount that has been agreed by the parties as what should be paid can be brought by way of an action under the underlying, for instance, where someone is under unemployment, he knows what his salaries or allowances are, they have been determined, they are fixed, and there is a breach of that contract of employment with respect to the payment of the salaries and emolument. A person can bring an action under the undefended list for the purpose of the recovery of any outstanding salaries or allowances. So where you have a scale, for instance, that can be referenced for the purpose of determining the quantum or the amount of money or damages that one is asking for, it is something that can come under the undefended list procedure. That is to say that where you have a course of action that will require the court rendering opinion with respect to what amount of money can be awarded as damage, that cannot qualify as a liquidated demand. That is to say that where, for instance, negligence, Court A may decide to add an injury as a result of the negligent at the same matter. It is not award in terms of the quantum of the award that the court will make is not necessarily going to be the same as what Court B would also award the same facts and same parties and court. So these are the distinct what a liquidated money demand is and what an unliquidated demand is. And as for the purpose of the undefended list summons, it is only for claims that are liquidated in nature. So I would take order 12 of the Federal High Court Civil Procedure Rules. Number one, it must be a liquidated money demand. And in the undefended list summons, you have to have a writ. It's brought by way of a writ that is supported by an affidavit. And in that affidavit, you have to state clearly that the grounds upon which the claim is being brought. You have to also state very clearly in the affidavit that in your belief that the defendant does not have a defense to the action. But of course, in addition to that, you don't just make such a bare statement in the affidavit. You have to demonstrate by evidence, by affidavit evidence, bring documentary evidence to show that him to pay and that the defendant does not have a defense to the action. The affidavit that you are filing for the purpose of the undefended list summons should be able to demonstrate to the court that that is the case. And now once that undefended list, once that writ is filed together with an affidavit making all depositions in the affidavit, the court is going to look at the nation. Whether the court is satisfied, it is likely that the defendant will not have a defense to the action, or prima facie that yes, there are good grounds for believing that there is no defense to that particular action. And once that is done, the court will give an instruction that the suit be placed on the undefended list of the court, and it will be so marked, and the process would be served on the defendant as an undefended list of that writ. Okay, by the time the summons is being served, it will be fixed for a return date. A return date will be slated fixed for the hearing of the very first time that an order of hearing. And that is why in allotting or fixing the date for a return date for the hearing of the undefended list summons, the court usually would take into account the number of days filing a notice of intention to defend. And if someone is to file a notice, he has to do that. We have seen authorities where defendants were accommodated even after the expiry of those dates, but it is important that you adhere strictly to the rules of the court with respect to time within which that process is going to be filed. Now, it's important that in the notice of intention to defend that you demonstrate clearly in the notice. That is because if you make just a bare statement, just a general traverse of the claim of the plaintiff, you are not likely to get the court exercise its discretion in transferring that matter to the general cause list. So you have to demonstrate in your affidavit that accompanies your notice of intention to defend that you do actually have a very good defense on the merit for the court. So where you successfully disclose in your affidavit that accompanies your notice of intention to defend, that you have a good defense or a defense on the merit against the claim by the plaintiff on the undefended list summons, the court would grant you leave to transfer the matter to the general cause list, in which case pleadings may be ordered, or there are also instances where parties can agree to proceed with the matter adopting the affidavits on both sides, both the affidavit that accompanied the writ of summons for the plaintiff and also the affidavit that accompanied the notice of intention to defend for the defendant. So when leave is granted, the court would take parties, witnesses who would testify on the basis of the affidavit evidence. If there is need for them to be cross-examined, such witnesses will be presented for cross-examination, and then the matter would be heard as though it were an ordinary summons. But where the court is not satisfied that the affidavit in support of the notice of intention to defend discloses a defense on the merit, the court is going to enter judgment. And once that judgment is entered, it is a judgment on the merit. It's not such a judgment that you can set aside. You can only appeal against this particular judgment. Now, let me just quickly go to, I know maybe there might be questions on this. I would leave this quickly because of time to begin to talk about the summary judgment procedure under the Lagos High Court rules. Now, something that is akin to the undefended list summons, but then there are also some differences between the two, is the summary procedure. With the case of summary procedure, what a plaintiff does, or a claimant, is that if he believes that there is no defense to the action that he has filed or is about to file, what he does is that he prepares his statement of claim. I mean, he prepares his originating summons, which will be accompanied with the statement of claim, and all the other processes that you have to front load, the list and copies of the documents, the witness depositions, and where there is need, for instance, in the FCT High Court for a certificate of pre-action certificate to be issued, all of those documents that must necessarily accompany the originating process are filed, and alongside those documents, the set of documents that must accompany the originating process, the plaintiff then files an application. That application would be asking the court for summary judgment on the basis of his belief that there is no defense to the action. Then he would file an affidavit. Of course, the application will be by way of motion or notice, supported by an affidavit where the grounds of his belief would be clearly demonstrated in that affidavit. And it will be accompanied, the Lagos State High Court Civil Procedural Rules talks about a written brief, but we would understand that to be a written address that would accompany that process as under the summary procedure. Now, that process is served on the defendant. If the defendant is served with that particular process, the defendant has an option under Rule 4 or the 13 of the High Court Civil rules of Lagos State, the list of depositions of his witnesses to also use as a defense to the action of the plaintiff. And then you would need to file a counter affidavit and a written action. Don't forget, after filing the originating process with all the accompanying documents for a summary judgment procedure, the plaintiff had filed an application asking the court for summary judgment. That is to say, we don't need to go into full trial because I believe the defendant does not have a defense to this.
Hi, Tobina. I think the Leonard Silk's internet has gone off again.
So give me judgment summarily on the basis of what I'm asking for. Now, the defendant needs to file a counter affidavit to that application. I would advise that in doing so, even though you may have front-loaded all the cotella, I would suggest that
let us say we're struggling with hearing you. You're on mute at the moment, but we're generally struggling with hearing you. It might help if you go off the camera so that perhaps your bandwidth will perform better. Leonard Silk Yakubu, you appear to be muted or frozen rather. Yeah, the Leonard Silk appears to be having connection problems, so we'll just wait for, okay, he's back.
Can you hear me now?
Yes, we can hear you now. Thank you.
I'm so sorry. To do this from here, I had to come with several network service so I had to switch to another one. I apologize. Now, I was talking about for the plaintiff for the claimant under the summary judgment procedure. Don't forget he had front-loaded all his documents and has filed a motion to ask the court for summary judgment because the claimant believes that the defendant, there is no defense to the action. So for the defendant, front-load all the documents and also file a counter affidavit. And I was at the point of saying that I would advise the defendant in this particular case in filing that counter affidavit. It won't cost you anything. If you can, please reproduce all the documents that you have in your statement of defense, even though it's before the court. And I know that the court can look into documents that are in the file of the court to make a decision one way or the other. But I think it would help you who is trying to demonstrate to the court that I do have a defense to this action, to make it easier for the court to handle those processes by making all the available evidence that you have to demonstrate that you have a defense to the action. Also accompany your counter affidavit that comes, the counter affidavit to the application for summary judgment. Very important. I have noticed that in the Kaduna State High Court rules, there is no requirement for a counter affidavit. It only requires that the defendant files a written address. If I would advise that even in such situation, I don't think if one would file a counter affidavit in that case, that the court will frown at it, because it's safer for you who is responding to an application that was accompanied by a counter affidavit for the purposes of the facts that would have been deposed in that application, in that affidavit. I think it's important for you to also file an affidavit in order to meet those allegations in the affidavit in support of the application, and also accompanying them with your documents. That way, the court is saved the trouble of having to be making cross-references in dealing with your application. Yes, I agree the documents are in the defense. So that is what the court is going to consider. You would notice in the summary judgment procedure, there is not a prescription or limit to the type of action that can be brought under the summary judgment procedure. But such a procedure can also not be adopted for the purpose of claims for declarations. Why? Because these are claims that would require that evidence be led, because you cannot ask or get the court to grant declaratory reliefs in the favor of a claimant, except that the claimant has led evidence to demonstrate his entitlement to those declaratory reliefs. And you can't also grant declarations on the basis of admission by the defendant or even the failure of the defendant to file any defense. So that would be one of the differences between the undefended list procedure in terms of the nature of claim that can be put on it and the summary judgment procedure. So, but largely other claims can be accommodated under the summary judgment procedure, essentially just satisfying the requirements of the rules with respect to what the claimant needs to show for the purpose of getting summary judgment granted to him. Now, the court would consider the counter affidavit that is filed to see whether there is a good defense to permit the defendant to defend the action, and where it appears to the judge that the defendant has a good defense and ought to be permitted to defend the claim, the defendant may be granted leave to do so. But where it appears to the judge that the defendant has no good defense, the judge hearing that application in the summary judgment procedure would refuse to grant leave to defend, but go on to enter judgment in favor of the claimant. And where it appears also to the judge, if there are several defendants in the action and or maybe a certain part of the claim is what the defendant has failed to demonstrate a good defense to, the judge can sever that aspect of it. If the claims are severable, the court can do so and enter judgment with respect to the one for which no good defense has been provided by the defendant, and proceed with the other parts of the claims that the defendant has not shown a good defense, or the ones that the defendant has shown a good defense. So judgment can be entered for part of the claim, and then the other part of the claim would also proceed to trial. And where there are also several defendants, it can be applied if the claim of one of, or defense of one of the defendant does not affect the other defendant. If they can be separated, a claimant can also ask, even where there are several defendants, for summary judgment with respect to one of the defendants. And before I leave the issue of the undefended list, I would like to just make reference to a decision that was delivered by the Federal High Court on the 22nd of June this year. It's a judgment that's been widely publicized. It's the judgment between the Attorney General of Rivers State and another, and the Attorney General of the Federation. It was delivered by my Lord Honorable Justice Taiwo O. Taiwo on the 20th. That is a suit that was brought before the Federal High Court on the undefended list summons. Now, reading through the judgment, one would see that in requesting the court to place it on the undefended list summons, the plaintiff brought an application ex parte to asking the court to place the writ on the undefended list summons of the court. Now, previously, there were conflicting decisions of the court because the opening paragraph of the rule, the order says where an application is made to the court for the issuance of the writ of summons. And so there had been a debate as to what would be the nature of that application. But of course, that particular rule also says that it will be the writ of summons as in Form 1 that is supported by an affidavit. So, but we had in the past cases, conflicting decisions of the Court of Appeal until it was finally settled that once you file a writ of summons supported by an affidavit, you have satisfied the requirement of that rule. But I think in this particular case, counsel decided to err on the side of caution, filed an application ex parte for the suit to be placed on the undefended list summons of the court. Now, when a summary judgment procedure is taken and the court enters judgment, just like in the case of the undefended list summons, that is a judgment that is entered for the claimant on the merit. And if you have to seek to set aside that judgment, you would not succeed in doing so before the same court that has delivered the judgment. because the court would have become functus officio, and the only option that you have is to proceed to the Court of Appeal and appeal against that judgment. So that is it for the undefended list summons, and that is it also for the summary judgment procedure. The other thing that I've been asked to talk about is the judgment on admission. And I will talk briefly on judgment on admission and then come back to the default. Now, judgment on admission, or the 21 of the rules of Lagos State, allows for parties to give notice to either party, may give notice to either party if he has admitted either wholly or in part the truth of what is stated in the other party's pleading. Now, such a notice would be issued, but then, and it could be done by either of the parties, and the essence of doing so is just to make sure that those issues that have been admitted by the parties, the time of the court is not wasted in hearing them. That is because also there is only a dispute between the parties when parties disagree. But when there is an admission, and we know that what has been admitted requires no proof, so if there is anything part of the plaintiff's claim, for instance, that a defendant is admitting, then the defendant is free by virtue of these rules. In fact, he is mandated, is required by virtue of these rules to indicate his admission of the particular thing that the claimant has stated in the statement of claim. Otherwise, there is a provision in that same rule that says that if for any reason you neglect or you fail to admit what you should have admitted, then at the point that the court will discover that you have failed to do so, the cost that will be incurred for the purpose of bringing, or the cost that had been incurred for the purpose of bringing that proof would be borne by you. For instance, Mr. A ought to have admitted a certain allegation made by Mr. B in his statement of claim, but Mr. A refused to make that admission. And for the purpose of proving that particular allegation, Mr. B now had to ferry a witness from Sokoto to Lagos, where this matter is being heard, for the purpose of demonstrating to the court that particular allegation, only to discover that that needn't happen because it was not something that was denied, or was deniable, but then the defendant failed or refused to deny it. Then the court would award the cost of bringing that evidence, that proof, that witness, or whatever form of evidence that you would require, or for the purpose of demonstrating that which ought to have been admitted but was not admitted, you would be made to bear the cost of doing so. And why is it that matters of this nature, the rules are provided that admissions be made, of course, to save the judicial time of the court, precious judicial time of the court, and also to save cost of the parties. The courts are interested in making sure that disputes are settled with minimal costs to the parties. So, and that takes me back to this judgment that I mentioned earlier of the Attorney General of Rivers State and the Attorney General of Federation. If you permit me, I would read an aspect of that judgment, and I will make 2 points there with respect to admission. His Lordship stated that it is the law that once a judge is satisfied that the plaintiff has fully complied with the provisions of the applicable rules, in this case, or the 12, that the defendant is clearly seen as not having a defense on the merit to the claim. The trial judge has no discretion in the matter any more than to enter judgment in favor of the plaintiff in accordance to the relief sought. This is undefended leave summons, and once the court finds that There is no defense on the merit. The only duty that is left for the court, that is on the court, is to enter judgment. Before a defendant could be allowed to defend under the undefended list procedure, he must satisfy the court, and His Lordship stated all the things that the defendant would have to show. A mere denial, His Lordship said, is not enough, and that the defense must be on the merit, it must not be a sham, and all of that. And the court went on to find that I have above alluded to these processes and touched on the affidavit to show defense, especially the admitted paragraphs and the exhibits attached thereto. I have also pinpointed the paragraphs to which the defendant is silent and offered no explanation. That is the point that I want to make. If you are filing processes, number one, you are silent about certain allegations that are very crucial in the claim of the plaintiff. You haven't said anything, you haven't offered any explanation. I listened to Uncle Ken Mosier when he talked about pleadings, and he was admonishing us to make sure that in filing our defenses, we should be categorical. We should not be evasive. We should not be silent about allegations that are made against our clients if you are representing the defendant, or refuse to offer any explanation. Now, this is the consequence of failure to do a thing like that. On the whole, I am of the view that the defendant, that is His Lordship speaking, has no defense to this action, especially where his sole defense is that he has not recovered any amount which is admitted. Aside from the vague deposition, talking about vague deposition, the defendant has failed to convince the court with credible facts backed by documents that it is yet to recover any sum of money from the oil companies. Also on the need for you to support every allegation that you have made or the answers that you are giving. His Lordship said, I find also that the defendant has failed to demonstrate that he has a bona fide defense to the plaintiff's suit. The notice of intention to defend the action is too vague. It is not enough for the defendant to state that the defendant intends to defend this suit at the hearing. Now, for both the undefended list summons and for the summary judgment, if you are filing a counter affidavit to the motion for summary judgment and all you say is that you as a defendant, you intend to defend this suit at the hearing, that is not going to make the court grant you leave to defend that action. And for the purpose of the undefended list summons, as it is in this case, the court also held that it is not a good defense sufficient to convince the court that there is a defense on the merit to warrant transferring the matter from the undefended list to the general cost list. So it is important, while you make sure that you admit where you need to admit the allegations made by the claimant, it is also important that where you have to deny, you also have to do the denial properly. Otherwise, consequences would follow. Judgment can be entered against you, and for summary proceedings and some summary judgment procedure and the undefended list procedure, the judgments are on the merit. You cannot go back to that same court and seek to set aside those judgments under the undefended list or the summary judgment procedure. I would leave the summary judgment procedure and the undefended list. If there are questions, I will be happy to attempt to answer them and then move to default judgments. Now, there are two types of defaults. Number one is default of appearance, and number two, default of pleadings. Now, under the rules, under the rules of court, defendants are mandated to enter appearance whenever they are served with originating processes. Now, if a defendant is served with an originating process, is under obligation to file a notice of, a memorandum of appearance, file a statement of defense in order to indicate that he intends to defend that particular action. In some cases, you find defendants not doing so. Where a defendant refuses to appear to a writ of summons, judgment can be entered in default of that appearance. And where such judgment is entered in default of the appearance, it is called a default judgment. But then such a judgment is not a judgment on the merit. It can be set aside subsequently. In the rules of court, and that is why I would advise that wherever you are taking up a matter or wherever you are conducting any proceedings, try to acquaint yourself with the rules of that court. For purposes of appearance, if a judgment is entered in default of appearance, in some of the rules of court, you will discover that a certain number of days is given for the defendant within which to apply to set aside the judgment in default of appearance. And if the matter was dismissed or struck out, as the case may be, even though the expression dismissed may be used in the particular rule, but because the rights of the parties have not been finally determined, that dismissal would be interpreted as striking out. It is not a final decision of the court, it can be set aside. So a party can bring an application, so you need to know if there is a time limit within which that application ought to be brought. If there is no time limit, you go straight and apply. But if there is time limit, make sure that the application is brought within that time. And if you are past the time limited by the rules of the court for the purpose of filing the application to set aside that order and get the matter back on the list of the court, so that the matter can be had on the merit. If you are now prepared to file your statement of defense and all the necessary documents, you better do so, so that if you are out of time, you also need to have the Trinity prayers asking for extension of time within which to seek to apply to set aside that judgment and all. So you'll be able to have a proper application. Otherwise, if the application is also irregular, you will not be able to succeed in setting aside that judgment. Now, that is it with respect to appearance, and there is also default of pleadings. If a defendant fails to file a pleading when he should file a pleading, the plaintiff can also ask the court to enter judgment on behalf of the claimant. Now, with respect to the default of pleadings, even though you can apply to set aside the same judgment that would have been entered in default of pleadings, there are certain limitations that are placed with respect to such application. For instance, Order 22, Rule 12 of the High Court Civil Procedural Rules of Lagos State, it says any judgment entered upon default under this order or any provision of these rules shall be final and valid. That same provision is also found in the High Court of the Federal Capital Territory, Abuja. And then, so Rule 2 says, the judgment may be set aside upon application to the judge on grounds of fraud, non-service, or lack of jurisdiction, and on such terms as the court may deem fit. So you can see that for default of pleadings, the rules of court have limited the scope of the application or the grounds upon which it can be set aside. You cannot just go to court. You have to bring your application within the ambit of what the rules have provided. You have to come by way of fraud. Non-service, we know non-service goes to jurisdiction because the absence of service renders proceedings a nullity. And lack of jurisdiction, if the court at the time it entered that judgment has no jurisdiction, then those are the grounds upon which you can seek to set aside a judgment entered in default of pleadings. Otherwise, the same rules say that such a judgment when entered becomes final and valid, as opposed to the default of appearance, all you need to do, default is setting aside, if you look at Order 12, Rule 9 of the High Court Civil Procedural Rules of Lagos State, it talks about where judgment is entered pursuant to any of the preceding rules of this court, a judge may set aside or vary such judgment on terms upon an application by the defendant. And then 2, the application shall be made within a reasonable time, showing a good cause, a good defense to the claim and a just cause for the default. So you have to explain your failure to enter appearance within the time prescribed by the rules of court. You have to also bring your application within reasonable time. And of course, reasonable time would depend on the circumstances of the case. That is something that you have to demonstrate in your affidavit in the application, and that to demonstrate that you are serious, you have to also bring in your application together with the statement of defense and all the documents. This would require the exercise of the discretion of the court, and we know we have to place materials before the court to enable the court to exercise the discretion judicially in our favor. So it's important to look at the rules of the court. Like I said, this particular rule has not prescribed or fixed a limit or time limit within which the application can be made, but other rules of court, for instance, state that such application to set aside the judgment entered in default of appearance would have to be made within 6 days, for instance. And so you need to know that you need to look at the rules of the court, relevant rules of court applicable to the matter that you are handling, to know what you are supposed to do should you find yourself in this situation. So I don't know if I've done an hour already on this. Otherwise, maybe I should just stop at this point, and I'll be happy to ask to respond to questions if our delegates here, and I'm sure they would have some questions. Thank you very much.
Thank you very much, Leonard, Senior Advocate of Nigeria. Thank you. I'll now invite Litigation to take us through question times before coming back to you in substance. Thank you.
Okay, so we just have 3 questions so far. So please, everyone should put their questions in the chat box. Sorry, the Q&A section. So I'll just start with the first one from Chiamaka. She says, where the claimant is unable to serve the defendant with the process in a summary judgment procedure because the defendant has moved to another country, what does the Leonard Silk suggest is the best way to serve? What does the Leonard Silk suggest is the best way to serve the process? Case law on service through social media or via email is not yet clear and is mostly from magistrates. Sorry.
Well, so if I presume if it's out of the jurisdiction of the court, that is out of the Federal Republic of Nigeria, I presume that you know where he is. If you know where he is outside the country, then you should resort to the rules of the court, the relevant rules of court, and the rules of court make provision for the service of processes outside the Federal Republic of Nigeria. So I would suggest that you resort to the relevant rules of court, see what you are supposed to do, and effect service on the defendant who is now outside the jurisdiction of the court, and I assume in this case outside the Federal Republic of Nigeria. And again, there are rules of court already that that allow for service through electronic means, emails, for instance. So please look at the rules of court. There are provisions for the rules of court allowing service of processes via email and through some other electronic means. Thank you.
Okay, so Sekav is asking, in a situation where a defendant does not file a counter affidavit to an application for summary judgment and argues that his statement of defense suffices at the industrial court, can it be said that he has challenged an application for summary judgment?
Sorry, I don't.
Yeah, I didn't get that. The industrial courts actually, but just
everything.
Yeah.
The doctrine of the industrial court actually took away.
So is it possible to answer the question without, taking out the industrial court?
Can you read the question again?
Okay, so in a situation where a defendant does not file a counter affidavit to an application for summary judgment and argues that his statement of defense suffices, can it be said that he has challenged an application for summary judgment? I took out the industrial.
So I asked the question. You've been served with an application for summary judgment, having been served with the originating process with the accompanying processes. And now there is also, in addition, an application for summary judgment. You have filed a defense because I presume you must have filed that defense before you can now argue before the court that your defense suffices. Why wouldn't you do what the rule says you should do? For summary judgment, yes, you have filed a defense, but the rules also say that because it is summary judgment procedure, file a counter affidavit and demonstrate that you have a defense, a good defense to the action. Why would you not do that? The rules of court are meant to be obeyed. So I don't know why you would choose to disobey the rules of the court and yet ask the court to grant you an indulgence. I don't advise you do that. Whatever the rules require you to do, please go ahead and do so. Don't take quarrel with the rules. They are meant to help you to deliver your services to your clients the best way you can, please. Thank you.
Okay, so Paul is asking a very kind of personal question. So he says, my application for summary judgment for a recovery of a debt once failed because the writ contained a declaration that the defendant breached his contractual obligations owed the claimant. How would you advise counsel to frame their prayers to avoid being caught in this web?
Okay, so I wouldn't know what exactly happened in that particular case, but if you have a claim for declaration that someone breached a contract, possibly the claim, what you now consider a liquidated demand, is tied to that declaration being granted. If that is the case, then it is not a liquidated demand because now the court has to make a determination. It's not as if you had agreed that, okay, where there is a breach, this is what I'm going to ask for. You do not have any, you just first and foremost, you want the court to determine that there is a breach, there is a declaration that there is a breach of contract, and then consequently grant me damages. That would not qualify as liquidated damage. And perhaps that is the reason why that decision went that way. I do not know. I don't have all the facts, but I guess that may have been what happened.
Okay, so Blessing is asking where a case has been brought under the undefended list procedure, and there is an application to the court to defend same, which is granted. Subsequently, the court is satisfied that there ought to be an admittance by the defendant. Will it be right that the court gives orders for costs against the defendant, considering that the court earlier gave an order enlisting the case in the defended lists? Wouldn't it be the court approbating and reprobating? There's something. Did you get that, sir?
Well, I'm trying to.
It's a question coming by 413 by Blessing. So I'm just reading that out.
If the court had already looking at the undefended list summons and said,
Yes.
well, prima facie, this is something that should be placed on the undefended list summons of the court. Okay? That he does in chambers. He looks at the process, he looks at the documents that have been attached to it. You are claiming 10 million, for instance, for services rendered for which consideration has not been paid, and a check was issued to you for that purpose. An agreement for that service was also attached. The amount of money is stated there, and there is a check that is issued to you which for which you didn't get value. And by the time you take such a claim before the court looking at those documents will say, oh, prima facie, this is something that should go to the undefended list summons. Okay, and then you come with your defense. If you cannot successfully explain how that you have an agreement with this gentleman to render certain services to you, how that he rendered that service, you enjoyed the service, you got value for the service, how that you are supposed to pay him 10 million for which you failed to pay, and you gave him a check for which he didn't get a value. If you can't explain that, nothing stops the court from entering judgment on the undefended list against you. And if you attempt to bring a sham defense, the court will also grant cost against you. So depending on the circumstances of the case, the court will look at your conduct and see whether the court would award costs, so that it would deter you from doing something of sort subsequently or another time, assuming you are the sort of person that like to do that, and you come before that court or another court. But it's important that if you do not have a defense to an action, why don't you go to court? Even if you don't have the money, go to court, submit yourself to the jurisdiction of the court, and you can ask for instrumental payment. That is the way that you can, but rather than do a volte-face, you go to court, you do not have a defense, of course, the court would award cost against you.
Okay, Ikechukwu is asking, can the court enter judgment suo motu on its own where there is a default of pleadings?
Well, the court can, but the court shouldn't. Otherwise, allegations of bias may be made against the court. The rule says that the claimant should apply. So let the claimant apply to do so. There is also a situation where maybe both of you are not in court, and if there is a reason for the court to believe that the matter is not properly defended. Now I'm talking about the plaintiff, not prosecuting the matter. The court can strike it out. But if it has to do with entering judgment, because that is also default judgment, when a plaintiff ought to do something and is not doing with respect to his matter, the court, in default of that which the plaintiff ought to do and he hasn't done, can also strike out the matter. But I'm talking here, I think the question has to do with a defense, default of defense. I think the plaintiff should be the one to ask the court to do so, rather than the court suo motu doing it for the plaintiff.
Okay, so Ibrahim is asking, when a case is finally and successfully set aside, which judgment is originally secured in default by the court, what would be the legal stand of that case set aside? Will the claimant file a new case or suit, or what will the claimant do in the circumstance?
So it's your processes are still there. It is the pronouncement by the court that, oh, your claim of XXYZ have been granted. That is what the court will set aside. So you go back to the position you were before that judgment in default was given. So once it is set aside, you don't do anything, your papers are there, they've been served. It will be for the defendant to take steps to defend the action. And by the time you lock horns by way of pleadings, you join issues, witnesses will be called, trial will take place, and then final judgment will be delivered on the merits by the court. So the defendant does not have to file fresh processes. Sorry, the claimant doesn't have to file fresh processes.
Okay, so Musa is asking, what is the way forward for a plaintiff who inadvertently filed a statement of defense, but the Commissioner of Oaths failed to stamp the witness statement, which was discovered after adopting the deposition, but before cross-examination? Is it proper for the plaintiff to apply to amend the statement of defense with another witness deposition, or how can one go about incurring the defect?
Well, so the endorsement of the Commissioner for Oaths is a requirement of the law, but at the same time, if it's the fault of the court, there are authorities that it shouldn't be visited on the litigant. And if you are talking about witness depositions, apart from the statement, the statement on oath that accompanied the processes, the witness would have to come to court, take an oath, and adopt that document. I think substantial justice would allow the use of that document without the necessity of having to call another witness to testify with respect to the same set of facts for which this particular defect or irregularity is found. That would be my take on that, but I wouldn't know how a judge would react to such a situation. But I think substantial justice would allow for the use of that document as it is.
Okay, so Usman is asking, is it in every situation where a claimant files a counter affidavit to the affidavit in support of a notice of intention to defend that the court will decide that there are triable issues to warrant ordering pleadings and transferring the matter to the general causes list?
Not in all cases. It depends on what you put there. If what you have in the notice of intention to defend, the affidavit in support of the notice of intention to defend does not demonstrate any defense, does not show any defense on the merit, the court will not transfer it. The court will go ahead and enter judgment for the plaintiff. Don't forget this particular case that I read out, the case of AG River State and the AG Federation. It was a similar situation. I mean, an attempt was made to file a defense, but the court looked at it and said, no, the documents that we have on this side are such that demonstrated a very good case. In the first place, I believed that it's such a case that may not have a defense, and that was why it was put on the undefended list. And if you are coming to defend that action so I can put it on the general cause list for trial, for full trial, then you have to do more. In this particular case, the defendant could not convince the court that it has a good defense to the action. So yes, it is not in all cases that the court will transfer the matter to the general cause list, even after filing a notice of intention to defend with an affidavit in support thereof.
Okay, Leonard, so that's the last question, that relates to your the points that you took. So I will invite Mr. Rojikwe.
Okay, thank you very much, Nta. I'll just invite the other panelists who are still with us to give their comments before returning back to the learned senior advocate. May I please ask Mr. John Bayesha, Senior Advocate of Nigeria, to make any comments that he would like to make on the presentation?
Okay, a very commendable and very strong presentation. I just say I concur with my brother Mikel as a finish.
Thank you very much, sir.
All right.
I'll ask Mrs. Maya Essien, Senior Advocate of Nigeria, to please let us have a comment.
Well, just like my brother Silk has just said, I don't have anything to add. I mean, my brother, Mr. Mikel Essien, I'm very proud of the presentation he has put forward. It was excellent. I don't have anything to add. Thank you very much.
Thank you very much, Leonard Silk, and thank you for having been here throughout. Thank you. May I invite Kelechi Mwaiwu for his comments. Kelechi, are you still there? Okay, I'm just seeing Mrs. A. I didn't know she was on.
Okay.
Let me invite Mrs.
Yes, I'm here.
Kelechi, we're having difficulty hearing you. Okay, Mrs. A, you can go ahead.
Right. I mean, nothing to add but to commend Leonard Brother Silk. Well done.
Okay,
Thank you for educating us.
Thank you, Mrs. A. Kelechi, we appear to be having problems with your sound connection. Okay. Before my closing comments on Mr. Mikhail's paper, I'd like to thank all the facilitators who have been present through today's training session. I also want to thank all the facilitators generally for the time that they have put towards this, the entire training. Starting from Mr. A.B. Mahmood, Senior Advocate of Nigeria. Again, I thank Dr. Nyechi as the Senior Advocate of Nigeria, Mr. John Baesha San, Mrs. Ma Esian San, Mr. Saroy Hoberman San, Mr. Ken Mozia San, Mr. YC Mikhail San, Mr. Emeka Anenubu San, Mrs. Abimbola Kereduru San, Mr. Elijah Yakubu Kura San, Mr. Wole Agumbi Ade San, Mr. Abdullahi Yaya San, and Mr. Kelechi Nwiwu. Of course, I will not fail to thank Mr. Tola Oshobi, who's acting at the interim dean of faculty. Thank you very much. Finally, Mr. Yakubu Mikhail, I found the paper very entertaining and excellent. Your Leonard Brothers Silks have made their comments, and I don't think I can add anything to what they've said. I can make a better comment than they've made. So, but thank you very much for your kindness, for being here today, for your presentation, which was excellent. Thank you very much on behalf of the Institute of Continuing Legal Education and on behalf of all delegates. Thank you.
Thank you so much. Thank you so much. You know, Mr. John Baesha is someone I've been watching for a long time. When they did the case of NEPA and Edegbero, I was coming from Sokoto, one slim boy from Sokoto to Kainji at that time. That was where I first saw the fireworks that took place in that court with him and Mr. Rabana. You know, wonderful. Those things really stirred a lot of things from us. So when I hear comments from him, from Our Lady with the panache, and then my sister from that oil-rich side that has also pulled my hands along in everything that she has done, I just know that I need to begin to do even more. But I thank you for your kind words. And by the special grace of God, I would continue to do more. That call that you have made is just for me to bend down and do more. And I hope that the little that I was able to share today brought value to the entire process. Thank you so much. I appreciate it.
Thank you very much, Mr. Yakubu Mikhail-san. Thank you, everyone, for attending. There won't be any trainings tomorrow. We'll continue again on Monday. And what a perfect introduction for Monday's training session, where we'll have Mr. John Baesha, Senior Advocate of Nigeria. I mean, Mr. Mikhail's commendable words actually should commend us to participate in the training on Monday. So, and we'll also have Mrs. Mea Esian, Senior Advocate of Nigeria, as a panelist and presenter on Monday. So thank you very much for participating today, and God bless you. See you on Monday.
Thank you.
Thank you very much. God bless all. Bye.